Hi everyone, you're watching The Caffeinated Corporate Lawyer, where we try to make meaningful content to help you better understand the intricacies of corporate law. I hope you guys are doing absolutely fine and are lightly caffeinated because today we are going to cover Section 9 and Section 10 of the Companies Act 2013. Section 9 deals with the effect of registration of a company. If you recall, in our previous videos we had discussed the process of incorporation of a company as given in Section 7 and that the ROC gives a certificate of incorporation to the company upon successful registration. Section 9 essentially talks about the effect of registration of the company and what is the immediate effect with the allotment of the certificate of incorporation. Section 9 states that from the date of incorporation mentioned in the certificate of incorporation, such subscribers to the memorandum and all other persons as may from time to time become members of the company shall be a body corporate by the name contained in the memorandum, capable of exercising all the functions of an incorporated company under this act and having perpetual succession, with power to acquire, hold and dispose of property, both movable and immovable, tangible and intangible, to contract and to sue and be sued by the said name. This means that from the date given in the certificate of incorporation, the proposed company stands incorporated and becomes a separate legal person which is distinct from its members. We can say that a certificate of incorporation is actually the birth certificate of the company because the company comes into existence the very date as is mentioned in the certificate of incorporation. Consequently, it exhibits all the characteristic features of a company once it comes into existence and becomes capable of exercising all the functions of an incorporated company. These features include that the company is a separate legal entity which is distinct from its members and it has perpetual succession, that is, it cannot end even if all the members and board of directors of the said company are dead. Being an artificial legal person, it can only be dissolved by the procedure as laid down by the law. It can also own property in its own name, and no member of the company can make a claim on the property of the company. It can sue in its own name and be sued in its own name as well. These are some of the well-known features of a company which you might have already studied, so we won't go into the depth of these concepts. Now, before the Companies Amendment Act 2015 came into effect, companies were also required to have a common seal, but now it has been done away with and it is only optional for companies to have their own common seal. All such documents which required affixing the common seal may now instead be signed by two directors or one director and a company secretary of the company. And consequently, several sections of the Companies Act 2013 dealing with common seal have been amended to incorporate the above requirement. Secondly, from the date of incorporation, the subscribers to the memorandum and all the subsequent members of the company become a body corporate. Therefore, as soon as the company gets incorporated, it will become a body corporate from the date of incorporation mentioned in the certificate of incorporation. Thus, all companies incorporated under Companies Act 2013 are body corporate as per Section 9 of the Companies Act 2013. We have already discussed the meaning and definition of body corporate in our previous videos. If you have any doubts, then you can click on the link above to watch that video. Moving on to Section 10 of the Companies Act 2013, which deals with the effect of Moa and Aoa. It basically talks about the effect of Moa and Aoa once the company is incorporated and it comes into existence. We have already discussed about Moa and Aoa in our previous videos. Again, you can watch it if you have any doubts by clicking on the link above. Moa and Aoa are the charter documents of the company where Moa talks about the main objective for which the company was incorporated in the first place. It defines all the possible scope of operations of the company and defines the powers as well as confines the powers of the company. Aoa, on the other hand, talks about the regulations of the company regarding how the company would manage its internal affairs and conduct its business. Section 10 subsection 1 states that, subject to the provisions of this act, the memorandum and articles shall, when registered, bind the company and the members thereof to the same extent as if they respectively had been signed by the company and by each member and contained covenants on its and his part to observe all the provisions of the memorandum and of the articles. Section 10 subsection 1 says that with the incorporation of the company and when the MOA and the AO of the said company are registered, there comes into existence a binding contract between the company and its members as evidenced by the memorandum and articles of association. Essentially, the MOA and AOA bind the company and the members thereof to the same extent as if they were signed by the company and by each member. So it sort of creates a legal effect in the sense as if it is a contract which has been signed between the company and the members, as per which both the company and the members have agreed to adhere by the provisions as stated in the charter documents. This means that the company is bound to the members and the members are bound to the company by whatever is contained in these two documents. So, members are bound to the company, or in other words, members are liable to the company. This means that each and every member is required to observe the provisions as given in the MOA and AOA, and he is bound by the same and cannot do anything which is contrary to the provisions stated therein. So, AOA are the regulations of the company which is binding on the company as well as its members. For example, if the AOA provides that the company can sell any of the shares of the member, if any debt remains to be paid by such member to the company, then he would be bound by such a covenant, and thus the articles would be binding and the company would have the right to sell the insolvent member's shares. Similarly, company is bound to the members or company is liable to the members. This means that the company is bound to the members by whatever is contained in its AOA and MOA. Thus, the company cannot do anything which is contrary to the provisions as stated in these documents. For instance, if the company is planning to spend money on any objective which is outside its objective clause, then the members can restrain the company from doing so on account of being an ultra-vires transaction. Similarly, if the company does not allow any member to enforce his right given under the AOA, then such a member can file a suit against the said company to get his rights enforced. To sum up, the AOA and MOA is like a binding contract between the company and its members who have to abide by the provisions stated therein. Coming to Section 10, Subsection 2, which states that all monies payable by any member to the company under the MOA or articles shall be a debt due from him to the company. This means that the company has the power to recover any debts which is due to it by the members under the MOA or AOA of the said company. So basically, the company can resort to several or any debt recovery mechanisms to compel the member to pay any amount which is yet to be paid by him. This brings us to an end. Don't forget to like, subscribe and share our channel if you like our content. For any queries or feedback, you can write to us at our Gmail ID. You can follow our Instagram page for updates on our videos. We'll catch you guys in the next one. Thanks.